All right, now we're on to the Fourth Amendment, probable cause, reasonable suspicion, and Terry stops. All right, Fourth Amendment has to do with searches and seizures, and it's a very important topic for any law enforcement officer to understand. Have you ever been searched? Most people will say yes or no. However, if you've ever flown, you've been searched. Well, how does that fall under the Fourth Amendment? Well, if you don't want to be searched, you don't have to be. You just cannot fly on the plane. So that is giving consent to fly on a plane to be searched. All right, can the police search your person, your vehicle, your home? According to the Fourth Amendment, unless they have reasonable suspicion or probable cause, they cannot. So we're going to talk about those levels. So if an officer has no information and they just see you and they think, I just want to search that person's backpack. A hunch could be something as, well, I think that person might have some drugs in their backpack. Suspicion could be, well, they're acting like, they may have some drugs. Anything at this level, a police officer does not have the rights under the Fourth Amendment to search someone, their person, their vehicle, or their home. Once we hit reasonable suspicion, the officer has the right to do what we call a pat down, not a complete search. We'll talk later. Probable cause means the officer can fully search, go into somebody's pockets, look in their hood, look in their shoes, and arrest somebody with probable cause. Then we have preponderance of the evidence that's used in a civil court to find the guilt of the defendant. And then we have a beyond a reasonable doubt, which is utilized in a criminal court to find the guilt of the defendant. All right, again, those are the two most important ones that law enforcement officers have to be concerned with, because the top three don't really matter, other than it's unlawful for an officer to search with those. That's what I mean by they don't matter, because officers should not be searching at those levels. And then the last two have to do with the court system. Okay, so here's a little bar graph that kind of shows where the amount of evidence an officer has to have with reasonable suspicion or probable cause. At the very end, you see court beyond a reasonable doubt. So if you were charged with murder and you had a jury, they would have to find you guilty beyond a reasonable doubt. So that kind of shows you where RS and PC falls in. All right, so no information means the officer doesn't know anything. So of course, can the officer search a person with no information? No, that would be violating somebody's rights. Again, if an officer has just a hunch, an intuition, again, an officer cannot search with just a hunch. Again, an officer has a suspicion. So I give an example here. Can an officer stop and search that person? No, an officer cannot. All right, now we're at reasonable suspicion. So if an officer suspects somebody of doing something in an effort to be proactive, the courts, through Terry versus Ohio, has said that an officer can stop that person. This is important. In Oregon, the officer can detain the person for a reasonable amount of time. Some states do that as well, reasonable amount of time. Other states, it's 60 minutes. So it just depends on the state. But the officer can't arrest the person with reasonable suspicion, but the officer can stop that person, can detain that person in Oregon for a reasonable amount of time, and can pat down that person. It's called stop and frisk, which means can check the person's immediate area for weapons or evidence of a crime, which is generally the front pockets or back pockets of pants or jacket pockets, something that's in the immediate area of the person's hands. All right, so can a cop search a person with reasonable suspicion? They can pat search. They can't fully search, they can pat search. All right, now we have probable cause. So probable cause is what you hear of when an officer or detective applies for a warrant. They must have probable cause that thinks that a person has something in their home or in their vehicle or on their person that's going to be an evidence of crime or a weapon. And generally, they put forward this warrant and a judge has to sign it, and that's how officers serve warrants with probable cause. Officers can also go out on a call. Let's say maybe there's a robbery and they stop somebody that fits the description of the bank that was just robbed. The bank tellers are brought over. They positively identify the suspect. The officers now have probable cause, which means that any reasonable person with that evidence presented to them that that person robbed the bank would say, yeah, that person probably robbed the bank. So that's probable cause. So yes, can a cop fully search somebody, meaning going inside their pockets, looking inside their hood, looking inside their shoes? Yes, they can. And that is under the Fourth Amendment. And again, we talked about a warrant. Law enforcement can obtain a warrant with probable cause. All right, so let's go into preponderance of the evidence and beyond a reasonable doubt. So again, preponderance of the evidence is in a civil case, meaning it could be landlord-tenant, it could be something monetary where you're suing somebody because they bought a vehicle for you and didn't finish paying for it. So in those civil cases, you only need to tip the scales. A little bit more than 50% means the person's guilty. However, in a criminal court proceeding, we have beyond a reasonable doubt. That's the highest amount of proof. So it's really tipping the scales. It's not 100%. You don't need video evidence, but it's more likely than not. All right, so again, civil court is preponderance of the evidence, and criminal court is beyond a reasonable doubt, which you have to know. Okay, let's talk about Terry v. Ohio. So this was in 1968. The facts of the case were that a police officer in Ohio saw two guys walking around. They were looking through the convenience store window. They were across from the convenience store. They would enter the convenience store and they wouldn't buy anything, and they were acting very strange. Another man joined Terry and his other friend, and the police officer thought these three men are casing that convenience store to rob it. So back in 1968, there was no such thing as reasonable suspicion. There was only a hunch, no information, suspicion, which an officer couldn't stop somebody or search them, or there was probable cause, which meant an officer could search the person and arrest them. So the officer went up, thought the three men were casing the convenience store to rob it, and he did a quick pat search. He felt on the outside of the jeans of one of the men, the coat of one of the men, and the man had a gun, and so the officer arrested Terry. Terry actually sued and said, I want this arrest thrown out. That's a violation of my Fourth Amendment. The officer didn't have probable cause. I mean, I could have just been standing there talking about what I wanted to buy. How did the officer know that? So it went all the way up through the Supreme Court, and the Supreme Court said, you know what? We want officers to be proactive, not just reacting to crime. We want them to be able to stop a robbery, for instance, before it occurs. So they added reasonable suspicion, which meant an officer doesn't have enough information or evidence to arrest the person, but can detain the person and do a quick pat down of the person. All right, so that just kind of goes over, you can pause it right here, but it goes over what I just said. As far as the stop and frisk and the difference between probable cause, or PC, or reasonable suspicion, RS. So make sure you understand probable cause means an officer has enough information that the person committed the crime, that there's enough evidence, and reasonable suspicion just gives the officer the right under the Fourth Amendment to pat the person down, not fully search them. All right. So prior to any search, law enforcement officers must ask the question, what do they have? Do they have at least reasonable suspicion? Because if they do not, then the stop that they make of somebody is illegal under the Fourth Amendment. All right, so when can a police officer question someone? Well, a police officer has the right to approach any person in a public place and ask that person a question. However, that person does not need to know to say who they are, and can walk away whether or not they want to speak to the officer or not. So when does an encounter become a seizure or detaining? Well, a permissible approach becomes a detention when, in view of all of the circumstances or the totality of the circumstances, a reasonable person in that position would believe that they were not free to leave in the presence of the officer. All right, when is a seizure allowed? It's allowed if the officer can point to specific and articulable facts that give the officer, here we go, RS, reasonable suspicion, or PC, probable cause. And when can an officer frisk somebody? Again, if they're detained and the officer has reasonable suspicion. And when can an officer see somebody? Again, when reasonable suspicion or probable cause is there. All right, so if a police officer conducts an illegal search or seizure, the officer does not have reasonable suspicion or probable cause, there are a couple things out there that you need to know about. One is the exclusionary rule. Basically say wrongful or arrested or detained persons may have a civil right claim or tort claim. So how does law enforcement know whether they have RS or PC? They study search and seizure law and Supreme Court decisions. And since there's always new Supreme Court decisions, an officer is always studying. All right, that ends this presentation of RS and PC.